Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. In this video, I want to talk to you about temporary detentions and a case that came to my attention, McCall versus Metro, some police officers, and the D Hotel. But first, let's kind of recap temporary detentions. And so, as you know, you can always do a consensual encounter, but that typically doesn't occur in your line of duty because you're doing vehicle stops in which you can't ask someone for consent to do a vehicle stop, and most of your stops, pedestrian stops, are based upon reasonable suspicion. So let's talk about reasonable suspicion stops. If you have reasonable suspicion to stop someone and detain them, you can detain them for a reasonable period of time, not to exceed 60 minutes. And during that time, you can ask for identification, you can conduct a records check, and we've talked about this in the past. There's a U.S. Supreme Court case, a Nevada Supreme Court case, that gives you authority to do that. And you have to investigate the crime. And once you have completed your investigation, which means that you've done a records check, gotten ID, and done everything else, your stop ends and you have to release the person. And as you know from previous videos, 60-minute rule is exactly that. You can't extend it. You have to either arrest them or cut them loose after 60 minutes. That's the end of the line for an investigative detention. So here is the case of McCall versus Metro. Officers received a dispatch to the D Hotel. This person was allegedly either doing drugs or selling drugs. Officers arrived, they detained the person, they handcuffed him, and within about 10 minutes they had completed their records check, done a pat down, no guns, they've checked video, there's no evidence that this guy was dealing drugs, and so the officer says, hey, you don't have any drugs, and so we're going to cut you loose. Problem number one. Instead of cutting the individual loose, they detained the individual for 8 more minutes for security to trespass the individual. That individual turned around, filed a lawsuit against the department and said, the officers unreasonably detained me. They can detain me to do their investigation, but detaining me for 8 minutes so that security can trespass me violates my constitutional rights. They detained me for a non-investigative reason. And so it went to federal district court, and the federal judge said, you're right. And because temporary detentions is clearly established law, and you can't detain someone for a non-criminal investigation, the court refused to give the officers qualified immunity. The department appealed up to the Ninth Circuit Court of Appeals, and the Ninth Circuit agreed. They said detaining someone so that security can trespass them isn't a part of a Terry detention. It unreasonably prolonged the detention. It's clearly established law. Therefore, the Ninth Circuit Court of Appeals said the officers are not entitled to qualified immunity. So what's the takeaway from this? First, don't tell the person you're going to cut them loose and not cut them loose. And then secondly, when a victim, a hotel, security says, hey, can you hold on to this person so that I can do whatever I'm going to do? And in most cases, it's going to be the business or the hotel wanting to trespass the person. You either have to get the person to consent to sticking around, or you have to cut them loose, because otherwise you're going to get sued for violating their civil rights and not get qualified immunity. So this is just kind of a learning experience for us. The officers are going to be okay. The department settled the case, and so they're not on the hook. But we have to take this opportunity to learn from these cases. Thank you for listening. If you have any questions, please contact me at droger@lvppa.com. Call me with any questions, whether it's job related or otherwise, and I'll do my best to help you out.
111, 110.